Yes. Uh, Good morning, good afternoon, good evening, depending on wherever you are. Today, we are super excited and lucky to have Professor Katharina Pister with us. This is the start of a new webinar series on rethinking capitalism and economic order. And we're really lucky that Professor Pister is sharing her valuable time with us. We all know Professor Pister, but a little bit of introduction is always good. Uh, Professor Pister serves as the Edwin B. Parker Professor of Comparative Law at Columbia Law School, which she joined in 2001. Previously, she had held teaching and research position at the Harvard Law School, Harvard Kennedy School, and Max Planck Institute for Foreign and International Law in Hamburg. Among the many works that she has done, one of them, we all know it, The Code of Capital and how law creates wealth and inequality. Personally, I have learned about her work through that book. And today she's going to talk about her newly released book, which is Law of Capitalism and how to transform it. And she has shared a few words. I would like to read it out for all of us. And capitalism seems unstoppable. Laws and regulation that are meant to contain its excesses can slow its expansion, but are unable to contain it. How is it that a system that relies too extensively on the law to code assets and capital is so resistant to legal constraint is the question that this book addresses. The answer lies in the fact that capitalist law is Janus-based. Its private law side empowers actors to use the law as a tool to build private wealth and power over others. The public law side seeks to rein in some of the actions, but it also protects private actors against the state interferences. This is how private actors rule over the others with impunity, shift the risk of their action on the society at large and environment. I conclude, that is Professor Pister, that private law needs a reset to ground it in principle of mutual respect and support among the private actor rather than exploitation and power. So with that, I would like to welcome you all once again. And Professor Pister, the floor is yours. Thank you for your time again.
Thank you so much. And hello, everyone. It's wonderful to be back to talk about my work. I think I gave a group at YSI a little preview of the book earlier because I, of course, have been working on it for a while. And so I might have given away some of the ideas. And Sedgwick just sort of, basically read the nutshell of what the book is trying to do. But let me try to walk you through the argument. And then we'll see what comes out of this. So thanks for the beautiful poster as well. And here I hope you can see this all. So this is the puzzle I posed myself at the outset of the book. And maybe we can just pause here for a second because I learned this years and years ago from Bob Putnam at Harvard, that one of the ways you can, sharpen your research and maybe also find out whether you have a real contribution to make is if you can pose a puzzle. And so the puzzle I posed myself when I was asked to write the book, and I should say a word about this as well. This is the first volume in a series of book that is coming out under the heading of a new legal synthesis, which is edited by Jed Purdy, now again at Duke, he was at Columbia for a while, and David Grewal at Berkeley Law School. And other books that will come out in the series will be one by Lev Menand on money, one by Lina Khan on antitrust, and then one on democracy by David and Jed. So when they approached me and said, would you write the first volume in this series about the law of capitalism? I paused because I had just published a book on capitalism, or capital. And so I'm moving in this book from the micro-institutional analysis of capital to a more system analysis of the system capitalism. And I'm thinking about how law contributes and what one could do from a legal point of view about the system. So I'm posing the puzzle here. Why is capitalism a system that is coded in law? Certainly capital is coded in law. And so if the core assets are in law, then I think the system is deeply legal. How is it that this system is so resistant to legal constraints? So again, in the Code of Capital, I'm basically saying, I'm taking different legal modules, the institutions of private law, which is private property law and contract law, trust, corporate law, collateral law, and bankruptcy law to some extent. I'm using these modules and saying if you combine them with different legal objects or with different assets, objects, promises to future payment, or ideas, you can create capital assets, which I define as wealth generating and wealth protecting assets. So just combine the law with any object, idea, or promise, and you can create capital assets. So that's the code. Then, I observe that very often when capital goes into extremes, because people code capital and they can make money out of this and they get the legal promise and they make it enforceable and they trade the stuff, at some point, and of course that's a prediction that Marx made much longer ago, but it bears itself out in history, you get crises. There are the inherent contradictions of a system that pushes beyond its boundaries, and you find yourself in a crisis. Typically, when crises arise, and even when massive crises arise, what we do is we're trying to use public law constraints to contain capitalism. So in the post-war era, we have capital controls because it was very clear to people already in the 1930s, certainly after World War II, that in order to rebuild the world, you had to kind of really tame capital. So there were capital controls put in place, a new monetary order put in place, financial regulation put in place, new labor laws. Even the US supported unions in South Korea and Japan to push against communism, of course. Welfare state to secure people on top of that, and the broadening of access to justice. And here I mean also to civil justice by reforms in civil procedure codes to make sure that people could also use the legal system to advance their own ends. And so ordinary people, not only powerful ones. And yet, when you look at these changes that were put in place, almost immediately after they had been put in place, you see a counter movement, the avoidance of the effects of these new regulations that started even without deregulation. So deregulation in my mind is always like the end point of a process that starts much earlier, where people find ways to get around the effects of the constraints that we have put in place. So you see, for example, when you put capital controls in place, you use currency swaps and other techniques to basically avoid the effects. You don't want to go directly against them because then transactions might be declared void and null and void, and you don't want that. But you want to basically escape the effects, and that happens all the time. I think something very similar, even more extreme, happened after the global crisis of 2008, because in 2008, yes, reforms were put in place, but the reforms were not even close to what people had done in the 1930s or after World War II. It was basically an attempt to patch up the system. So you have Basel III, you have regulation of banks. I think the regulation of banks has been largely successful, but most of the activities that banks had been doing prior to the crisis through subsidiaries and through other vehicles were now basically spun off into independent entities, the so-called non-bank financial intermediaries that have grown out of proportion, that are on par with banks today. So this is basically the new institutionalization of shadow banking. And so I think even here you can see even faster the regrouping of financial activities to avoid the impact of the regulation. The regulation is still there. Some has been rolled back already under the first Trump administration. They're doing more of that. But I think even without explicit changes in the rules, what you see is pushback, reinterpretations. And this goes to show that what some, practicing lawyers I've taught with and I know well have told me, they basically say you can make ineffective any public regulation. It just takes a little bit more time and makes the thing a little bit more complex, but we'll figure it out. I mean, you just put all the manpower of a huge law firm behind that, and you find ways to structure finance in such a way that it escapes existing laws and regulations. So that's basically, I'm basically diagnosing here my puzzle, or giving you some substance to say, actually, this is what's happening again and again and again. So, can we do something different? So let me step back and talk a little bit about how I think about capitalism as a system, not only about capital as sort of the assets that we're creating, and how the system is able to reconstitute itself through law. So first step in the argument is to say, that capitalism is a legal regime and basically must be a legal regime, because what it is really about is it's trying to monetize today expected future returns. That's kind of a leap, right? So you're hoping to get some future returns, but you want to trade the stuff today and realize it in cash if you can, and then use the cash and make other investments. That takes not just a village, but it takes a state and it takes major social resources, in particular the legal and the money systems. So these two systems enable and sustain capitalism and are being used to create private power and wealth. That's for me the essence of capitalism. In this book, I'm talking only about the legal system. I don't touch money because Lev Menand is writing a book about this. But as some of you might know, I just gave the Adorno lectures in Frankfurt, Germany, which were about money, and I'm going to write a book which will come out first in German, but hopefully will be translated into English on the money system. Because this doesn't, I just have to, I have to address it myself. I think Lev will do a great job, but I have to kind of put my own mind to that issue as well. So to crack the nut about, not only you can state capitalism as a legal regime, but what is it that makes our legal system capitalist is then the next question that came up for me. And so I started digging into the theories and the debates of the early 20th century about capitalist law. Now, today, when you go to any law school in the West, certainly nobody's going to talk about the fact that our law is capitalist, or that it at least has made a very capitalist turn, or is essentially capitalist. These are the debates, however, which raged, I think, the early 20th century, because, of course, with the arrival of the Soviet Union, an attempt to create a socialist society, the question was quite pressing about what is capitalist law, and is there something like socialist law, and what would it look like? So we have basically, I focus only on two opposing views. There are many more nuanced ones, but within limited time and space, that's all you can do. And I should start really with Karl Renner. Karl Renner was an Austrian legal theorist. He also was a chancellor after World War I and a president of Austria after World War II. So quite an interesting figure. He wrote a book already in 1908 on the private law institutions of capitalism. And he took a very sort of combination of Marxist materialism, but also when it comes to law, rather positivist approach, which is to say that the underlying economic conditions determine the content and the operations of the law. So if you change the underlying economic conditions, the law will change. So that's the direction of causality. And the law is basically a vessel within in which you pour different economic conditions, but you don't change the law to change the conditions, basically. Pashukanis actually made fun of Renner. He did not buy the argument because he just felt it was too simplistic to say you can just fill the existing legal structures with different form, because he argued that actually the law that we have, the capitalist law that exists today, has a commodity form. It is basically structured itself as a commodity. The other point that he made is that there is in capitalist legal systems necessarily, and one of the defining features of capitalist legal system is the antithesis, as he called it, of public and private law. So within law, there is, of course, a big debate about whether this distinction between public and private makes sense. Many people are saying, and the legal realists have said this for a long time, in principle, all law is public because all law relies on the enforceability through a state court. Pashukanis countered to that you could just as well say that all law is private because that's where it came from. And I think when you talk about private law, there's truth to that. You also want to have enforceability, but you all want to, on top of that, you want to have a legal regime that is largely self-ordering with enforceability at the background. That is always there. But the way that the law evolves and the interests that are being protected are mostly powerful private interests, and that has been true for Roman law and has become true in our legal systems as well. Okay, so based on my reading of these earlier literatures, I'm basically stepping back and I'm trying to say something first about the foundations of capitalist law, and then I'm going to explain how capitalist law evolves because of certain features that are basically built into the structure of capitalist law as we currently have it. So the very foundations, the principles on which capitalist law is built are first historical, institutional, if you want. Capitalism has preceded democracy, certainly our constitutional democracies. I think it's tied to the rise of the nation state, because the extent to which we can rely on enforceabilities actually comes only with powerful nation states. But we also have to concede that constitutional democracies came later, and in fact, they never said a word about the private law, really, that they embraced, except for endorsing it. So they basically took the existing private law with its feudalistic origins, if you want, and made it part of a legal system, which they then, on top of that, protected by protecting private property. They hardly ever define what private property means. It's basically entrenching the existing allocation of private law and the allocation of property rights in the constitutional orders that we have, and binding the state to do too much to change that. The second foundation of capitalist law is the duality of legal orders. This is the Pashokanis argument that I just mentioned before. And then finally, and that comes basically out of this already, there's a very powerful bias in favor of private self-ordering, which is reinforced by the features of capitalist law, to which I come now. So in my first iteration for this book, I basically asked myself, so when you have these crises and then we regulate and we're trying to contain capitalism, always comes back, what are the mechanisms that allow capital to always come back and reconstitute a capitalist system that we had just tried to contain? And I'm basically saying here 3 features of capitalist law that facilitate this. One is that the law empowers private actors, and not only individuals, but of course private entities, and private entities / corporations have expanded these powers quite substantially. And they have done this in part through the second feature, which is decentralized access to the institutionalized means of coercion. What do I mean by that? We often say that the state is the manifestation of the centralization of the means of coercion, right? So it controls the means of coercion. Max Weber, many others have said this. But we, of course, also grant people decentralized access to the means of coercion, and we do this through litigation. So civil procedure law, if you want, is one of the driest and most boring areas of the law if you go through legal education. But when you look at it from this perspective, it's actually quite important to think about who has standing to bring a claim, what claim is justiciable in a court of law, under what conditions, where do you have to sue, and who bears the cost of this litigation? Because if you can mobilize the centralized means of coercion for your interest, you of course have a major comparative advantage over everybody else. So that's the second feature. And the third one is legal arbitrage. So in legal arbitrage, I should just say, and I will say a few more words in the next couple of slides, is the ability to use existing laws to arbitrage around legal constraints without necessarily violating that law, so that you can escape the costs without being held accountable to that. So just a few words on each of them. Of course, when we talk about private empowerment, everyone will talk immediately about property rights, and I think that's true. I want to put 2 other important aspects on the books as well. One, of course, is that we have enshrined into our private legal systems the idea that we're all formally equal before the law, but we disregard any material resource differences. And that, of course, allows us to maintain the idea of sort of a fair and neutral legal system. And yet, of course, we're fighting with very different means. An old point, many have made this before, just want to put this back on the agenda. The other thing I want to just stress is that in the digital age, for sure, contract is the most powerful weapon to bind people, not property. If you can bind millions of people through information technology, through digital platforms, to the same contracts, the terms of which you have dictated, then you basically have universal type of control over them, which otherwise we thought only property rights do. So I think we have to go back and take a closer look at contracts, which is always portrayed as this liberal tool where people, when they meet their minds, they come to an agreement, but nobody negotiates anymore. Maybe in merger transactions, yes. And when I buy a used car, I negotiate, but I don't negotiate in everyday life, and I guess you don't either. Second, I mentioned this already, decentralized access to the means of coercion. So who has standing to bring what kind of cases, where, who bears the cost, what things can be litigated at all. These are all fine-tuned little aspects of civil procedure rules that I think, have to think about. Very important, especially in the United States, less important maybe in the European Union, depends a little bit on the country, is that private actors can also deny others access to courts. How do they do this? They write into their contracts arbitration clauses, mandatory arbitration clauses that also deny certain procedural rights that had been enshrined in civil procedure codes, such as in the US, discovery or class action suits. So in the US, the Supreme Court has sanctioned the use of mandatory arbitration clauses that strip these civil procedure rights from the other party, even for employment contracts and for consumer contracts. So if you read your contracts that you never read when you go on platforms, take a look. If in doubt, you have to go to arbitration and you don't know really what's going to happen because you don't know what rulings have come before and what kind of directions the arbitration might go. And surprise, surprise, most consumers or employees don't use these mechanisms with predictable results because then you can't fight for your rights. And then legal arbitrage is something that I've been talking about a lot already in the Code of Capital. Because law is general, you can interpret it, it changes, the interpretation changes, and it should change because the beauty of a relatively open-ended legal system means that we can adapt it to changing circumstances, new challenges, without having to go through the legislative process. How we do this really matters. On top of that, we have multiple legal orders that coexist with one another. You have municipal law and state law and national law. You have international law. You have regulation. You have private law. You have just multiple legal systems. And within the gaps and frictions between them, there's always an opportunity to sail through and to interpret these gaps in favor of one side rather than the other. Then, of course, one of the other aspects of having multiple legal systems is that the law gives you some rules about which system shall govern if more than one is in place. And when it comes to private law, most countries have adopted a position that tries to expand private autonomy. So basically, the parties can choose. This has been true in many jurisdictions for a long time for contract, so we can choose the law that shall govern our contract. But by also being able to say what law shall govern my corporation, I can incorporate it anywhere, and it will still be recognized wherever it does business. And corporations, of course, are key actors in issuing new assets that have property rights attached to them. You can actually also indirectly choose your property rights, even though, of course, for a long time, states had insisted that they control their territory. And they therefore can also control the property rights that govern any asset on their territory. But of course, financial assets don't have a location, a physical location, and that makes it possible to actually also escape the territorial reach of a state when it comes to property rights. And last but not least, you can also in these contractually agree on jurisdictions, either of courts or of arbitration. So these are the mechanisms. If you just want to think about a dynamic model, you say, coders of capital, the attorneys, they code capital in the way that I describe in the Code of Capital. This is like private law. They go into excess. Public law comes back and tries to contain it. And then you use again the same modules of the Code of Capital. And because we have such a bias for private empowerment, and you can use the court system to litigate strategically and arbitrage around existing regulatory constraint, you're breaking out of the system again and you're expanding private power. And then you're trying to, again, come back with public law constraints. So what do we do about this? I'm going to skip this because of time constraints. What can we do about this? So when I first came back to my faculty and told them about my ideas for this book, we always have like these workshops where we can share new ideas. I basically said, when you think about these three mechanisms, private legal empowerment, decentralized access to the means of coercion, and legal arbitrage, that's how capitalism will always reconstitute itself. And basically I said there's no way out. And I think we have to take this seriously when you have to take a very sort of sober and realistic assessment of where we are and what is happening. I think it's hard to escape that conclusion. My colleagues said you can't write a book with this kind of conclusion, and I think they are right about this. So then the question is, what if and how could you actually get out of this reconstitution of capitalism again and again and again? And it becomes even, harder to escape over time. So Logically speaking, I think if you believe if you are with me in arguing that capitalism is a legal system, it's deeply, not only capital assets are coded in law, but also the mechanism by which we protect, advance them, try to get these around sort of constraints, they're all deeply legal. That means we have to make it through law rather than outside the law, because also complex systems require some form of ordering. You can call it something else. And of course, we have the digital code coming along. But you can't really escape the need for relatively abstract ways in which we try to order our expectations so that we can interact with strangers. We can go back to communities as Engels and others have suggested. I think that's not a realistic proposition. So I'm just basically starting from complex systems need some form of relatively abstract order, call it law, call it something else. But that means is we have to change that order. You can't just chop off the heads at the top, as a revolutionary moment might do. But you have to change the institutions, and institutions change slowly and incrementally. And so the question is, can we actually do something about this? Now, what I want to say is that what we have seen in capitalism, of course, is that we have seen a major transformation also of our legal institutions and the entire system through law. Capital has done it. There's no fundamental reason that you couldn't do it in a different direction and exploit many of the features of the law that are today dormant but could be mobilized to that effect. So you can exploit gaps and openings in existing law. You can reinterpret law. You can use enabling features of the law to the extent that we have collective standing to go to court. And maybe we can also expand on some ideas. One of the ideas that I had expressed in an earlier paper, which I bring back into the book, is maybe we need some citizen councils for civil litigation. I'm not talking about jury trials as such. It's not the fact finding, but it's the lawmaking. And maybe there are ways in which we could use our imagination to think about how we can have more participation by people in this process. The common denominator for change that is not only multiple decentralized change in many different domains of life that just fizzles out. I think we have to think about how to ensure that that changes that happen already, of course, and people are fighting over these things all the time, that they do have a greater impact, and that requires, I think, that we have shared goals. And these must be based on shared norms. So let me say a few words. Hang on, I don't have. Yeah, let me say a few words about this. So in the book, I propose that one of the ways in which we can create a broad base for change, a broad normative base for change that ultimately is local and but directed in a similar way, is that we find a normative foundation that has wide appeal, but also allows us to change the system around. So I use in this book as an example, it's not the only one we can talk about this, but I use as an example the capabilities approach that Amartya Sen and Martha Nussbaum have developed. I go particularly with Martha Nussbaum because she has gone further in trying to also identify certain capabilities. And I think that's important certainly for a lawyer to do this. Why am I using the capabilities approach? First of all, I have to admit that I think, at heart, I am a liberal. I think that the individual matters, and that the individual is the most vulnerable entity, person in any kind of society. So I'm thinking about how to ensure that every person, and this is human persons, I will exclude legal persons from this. Only human persons have the right to live the lives that they have reasons to value, as Amartya Sen has put it. The beauty of this is that it is close enough to our rights-based world and our extreme individualism in the United States that people will have a hard time saying, I don't agree with this. Of course, everybody should have the right to live the lives that they have reason to value in principle. There is, however, a Trojan horse effect built into that framing of individual protection, which is the claim is not just against the state. You can't always say, oh, we'll just do what we want. We use private law and to the extreme that we can use private autonomy. And then you can go to the state and say tax redistribution, some regulation, and the state takes care of that. Instead, I think built into, and I think Martha Nussbaum is more explicit about this than Amartya Sen is, built into this approach is to say, I have a claim against you. you private actor, to enable me to live the life that I have reason to value. Now, how to institutionalize this? I think that's a long process, but that's where I want to go with this approach. I'm also mobilizing some work that has been done on the transplant effect. Some of you have read my very early work in 2003. I published a paper on the transplant effect, showing that with some economists also empirically showing that massive legal transplants that try to shift the legal system in countries, mostly developing countries, of course, during colonialism or afterwards, from one place to another, rarely, if ever, work. And so I've been very explicit about policy attempts to change laws radically in that way. And that also, of course, informs my thinking. But there was a group of economists, Aldashev is the lead author, who have argued and shown through fieldwork in West Africa that you can actually use law as a mechanism of change, but you have to be careful how you use it. So if you do radical legal change, example, women's right, if you make all women equal in deeply conservative societies in West Africa after independence, nothing happens. Society just rejects this law. Nothing happens. But if you enact a law that is sufficiently close to the social norms that exist, there are enough defectors that will go to the other side. And the people who are the guardians of the old normative systems will have to make a calculation. Basically, it's never that rational, but that's how they describe the model. They have to make a calculation about how far they have to shift to make sure that they don't lose their base. So that kind of gradual change in a certain direction is more effective in changing the norms than this radical change. And I think the capabilities approach to me has this kind of magnet effect built into this, given where we are. I know that many people have other more radical ideas about where we should be, and maybe we're going to be there at some point. For me, the question is always, how do you get from A to B? So what are the intermediate steps that one can take? I play with a couple of things in the book. One was a proposal that was made by Martin Hesselink, who teaches at the EUI in Florence. He had already proposed in response to my Code of Capital that we need something like a just private law code. He's thinking about like a soft code where we announce certain principles, how we want to interpret existing law. So the point for me right now is because the legislative processes are so stuck, and the powers that be will not allow us to make a major overhaul. And also, again, I don't think a major overhaul will change anything immediately because these changes have to trickle through. You can also do a bottom-up approach, and you use principles that you have to, however, formulate and announce so that we can push in a similar direction and sort of little change doesn't just fiddle out. And of course, that then would have to be also then, if you want to expand this and build on this, you need social mobilization, et cetera, et cetera. So, but I think that comes after you start a process within which you can show that there's a pathway through the institutions to change. So maybe let me just stop here. I've talked for a while and entertain some questions from the audience.
Thank you. Thank you very much. So now the floor is open for any question. Please raise your hand and ask your question. I can ask the first question. There is hand? No? Yes. Gaia, please go ahead.
Hi there. Thank you so much, Katharina. That was such an interesting presentation, and thank you for your scholarship. My name is Gaia. I'm a MA student in economics at John Jay College at CUNY. I'm very interested by what you were saying. I'd love to hear more kind of examples. One thing that I was interested in is your point about the limitations of using current approaches to, let's say, push for popular platforms like Tax the Rich. So I was just wondering if you could maybe give an example of how you might take a different approach to a goal like that using your logic. And the other thing that I was interested in is you mentioned that we need to sort of build a practice of having a claim against, like, the public having a claim against private actors for let's say stopping them from exercising their rights. And I feel like we're seeing a lot of that in the climate sphere right now. There's a lot of legal action. So I was just wondering if you wanted to comment on that, and is that something that you see as moving in the right direction? Thank
Yeah.
you.
Thank you. These are both great questions. So let me just say that if we can tax the rich, that would be great. And when I talk to tax lawyers and tax economists, of course, they say this is the simplest tool that we have to do redistribution. Why don't we use it? But I've also been on a call with German politicians and the Green Party lately. And the sense was there that it's certainly in the European Union, and I think the same is true in the United States, for the past 15 years or so, it has been impossible in any of the member states to really make major advances on the tax side. It's just going to be blocked. And so maybe Mamdani can raise some taxes here in the city. You know, we would hope that this is possible, but I think putting all our energy on these kind of things where you know where the lobby is on the other side, and also how they, of course, they will also evade, but they can't evade everything. Nonetheless, I think the reality check is it's not a straightforward path, even though it seems to be the simplest instrument. But everybody knows that, and everybody will fight it, and we don't have the resources to fight it as others have. I mean, you might be following the debate in France. I mean, even the socialists have backtracks from the Zuckman idea of a wealth tax. So that's basically what I think what we have to concede. And of course, given where we are in late capitalism, the resources on the other side and the legal tools and the sophistication of the lawyers are, you know, let's say they're truly on the other side, right? So it's hard to do this. I'm not saying don't do it. I say if you have an opening, of course. So, but it's not. I find very often that people want to do like international convention or like a new legislation or go to Congress or do the tax thing. And obviously, if things were easy, then that's what you do. In fact, even if you put this through, tax is easy, kind of, because you just tax. Many other institutional reforms have to be implemented and have to trickle down, and that takes years. And so I think you can also build up in years. Now, in the climate change space, there are some really good examples. And of course, you always get pushback, but you also get some help from Supreme Courts, right? I'm sure many of you who are in the climate space are familiar with the Shell case, where some Nigerian fishermen brought suit against the parent company in the UK. They also have a separate litigation. They also won in the Netherlands because Royal Dutch Shells, now all UK, but it used to be both. So you had basically damage done by a subsidiary in Nigeria for which they were trying to hold the parent company accountable. In standard corporate law terms, that's very hard because standard corporate law says the two entities, the parent and the subsidiary, are formally separate. And even if the parent holds 100% of the shares in the subsidiary, it benefits from limited liability, which is, you know, and you can pierce the corporate veil and cut through and hold the parent liable only if there was a clear abuse of corporate form, which is hard to show. What the Supreme Court in the UK did, and had done this earlier in other cases, was to say we're not piercing the corporate veil. We are invoking fiduciary duties, the duty of care, which basically says, I've oversimplified, but it says parents are responsible for their children, and we attribute the damages that children do to their parents. That's what I mean. Now, of course, Shell wasn't happy, and I know also that the fishermen were not happy because it took them 15 years to get there. From a legal point of view, it's a huge win. It's basically you can shift grounds and say, actually, we don't have to rely only on piercing. There are other mechanisms that we can use, and fiduciary duties are beautiful because they're so open-ended. That's just one example.
Thank you very much. So is there any other question that you want to ask? I have actually one question, but I want others to ask first. Yeah, my question was, there are one group of scholars who thinks that we have evolved as a society, as an economy, we have evolved so much so there is nothing can be changed from this point onwards. Like one is a famous book, as you know, End of History. So, so do you see that from that perspective, that our society has reached its limit and we won't be able to pull any lever anywhere because it's so much saturated that laws cannot be changed fundamentally?
I mean, I think, let me just say, like, from Fukuyama's End of History, I read this differently. I think he basically said,
extended.
yeah, but he basically said, now we finally, it's almost nirvana, right? And we have reached sort of the point where we've overcome socialism, and now we have the optimal model, and it's capitalism, and it always goes together with democracy, was it kind of implied. So it's and that will reinforce, and we will all be fine. Now, once we realize that we're not all fine, and of course we have to think about what to do with the system. I think, given that I analyze capitalism as a legal system and that our economic, social, political relations are deeply coded in law, that captures us, that constrains us in our ability to do things differently. At the same time, I'm also saying law is malleable, always been malleable. It's open-ended, can always be reinterpreted. The question is how we do this. So we have to free ourselves from the logic that there's only one way to think about this, that we also have to free ourselves from the neoliberal paradigm that we don't interpret the law anymore according to its purpose, its normative goals. We are interpreting the law because of efficiency in order to achieve some efficiency gains. And I think that has permeated into courts in this country. We know this from Olin-funded legal training programs for judges. So it's deeply, deeply ingrained in the thinking. Suresh Naidu here in economics has done this wonderful paper where he shows that judges who had attended these workshops use efficiency and words like that much more frequently after having attended than they did ever before. And justice and social, these things just are being pushed to the sidelines. But that tells you something important. It's how we deal with the legal system is critical. And what I'm trying to say with the capabilities approach, and again, I'm open to alternative approaches as well, is we need to build our legal system and we have to ground it again on normative principles. And we have to re-educate both lawyers and judges to how to use the law to achieve normative ends. And I think there is plenty of resource. If you go through case law, you can find plenty of examples where judges actually do this. And where also judges today find new openings to reinterpret the law in a different way. So I don't think we're stuck in that way. That would assume that law is completely rigid and has completely reined us in. And we are kind of paralyzed, but I think the paralysis comes as much from a lack of imagination and ability to re-see what is possible even within existing legal systems than from the law itself.
Thank you very much. Is there any other question? I have so many questions. Yes.
Hi.
Please.
Thank you, Katharina. My name is Marius Fokas. I'm a recent graduate from economics at UCL here in London. You referred to Rener's approach about how kind of economic underlying conditions kind of shape the regulatory landscape, right? And I want to ask, what economic conditions do you think will be enough to incentivize those legal professionals to kind of turn to innovation within their own domain to kind of deal with equality issues and well-being issues, for example, similarly to how we've done with climate change recently? What are those incentives and enablers that will sort of shape the new kind of regime of legal professionals to innovate in the field?
Yeah, it's a great question. So let me say, I'm also, like Pashukhanis, a little bit skeptical of this idea that, you just take the law as is and just fill it with different content. I'm, of course, saying the law that exists right now can be used in different ways, but it has to be, I think it has to be reset in a way that you overcome this antithesis of a public and private law. I should have said this at the end as well. What I'm trying to say is private law needs the reset. Sadwick sort of read my little blurb at the beginning. Private law needs the reset. It needs to be rooted on similar normative foundations as public law. So that is a preface. In terms of who can do this, I think, of course, those lawyers who, and I'm partly responsible because I work at a private law school that charges enormous fees for young lawyers who then have to go into big law to pay off their debt. And so then they get captured in the process of coding capital. So there's an entire machine that reinforces itself, which is why exit is difficult. At the same time, of course, there have always been other lawyers. The entire civil rights movement in this country was led by lawyers who found ways to create powerful rights for individuals, groups, and associations. Now they're currently being pushed back. So there's no unidirection, neither in politics nor in law. It can come back. And I think the only way to prevent it from coming back again once we make progress, and the only way to push for progress, is to have a deep normative commitment to certain things such as capabilities. So what lawyers who want to participate in this have to do is they have to forego the kind of income that you get when you go into big law. And that basically then also strangles you, because many students of mine who go into big law to pay back their debt, they then have a lifestyle that doesn't allow them to get out anymore, and then do a bit of pro bono to deal with the schizophrenia of that position. But I think many lawyers actually would like to do differently, and so they have to be incentivized. It's easier in systems where the debt burden is less of an issue, although I have to say, even in countries like Germany, where you have free education in law, many students are attracted by big law. It might change now a little bit. I do see that you can see this with people who have made it very open that they left big law after they kowtowed to Trump and caved in and compromised their principles as lawyers. They all basically had to swear on the Constitution, and then they pay hundreds of millions of dollars for pet projects of Mr. Trump. That, I think, changes also the mindset of people a little bit, and thinking, is this what I want to do? And so I've seen people then basically leave big law and set up their own boutique law firms, lower paid, but maybe also an opportunity to do things differently. So I'm not saying we first change the material conditions completely, but I think it's actually also a question of norms and minds, and drawing a line, so I just cannot do this anymore, and finding another way for work, and finding different groups of clients for whom you work and achieve ends in a different way.
Thank you very much.
Thank you, Katharina. There is another question from Mitra. Mitra, would you like to ask by yourself? I think that would be best. Otherwise, we have to read it out. Sorry, I cannot now. So in the chat, Katharina, you can see, I wanted to ask, what extent is the code of capital embedded in the structure, in the very structure of the modern nation state and international law? Can we envision a different legal order without transforming the state's sovereignty itself?
Yeah, it's also a great question. So yes, I think that over the last 200-300 years, we have emphasized the aspects of the private legal order that facilitate the coding of capital. I don't think that all institutions in private law necessarily are bound up with this particular way of interpreting them. And of course, some of them come from a feudalist order, which was not nice either, but certainly not capitalist. I think it's deeply ingrained. It's also become, and that's a real issue. It has become, of course, part of our transnational legal order. And just as a keyword, the state investor dispute settlement system, which has created a new form of property rights, which empowers, private entities, foreign investors, to hold sovereign states accountable in arbitration tribunal outside their own legal system and territory. And as you know, there have been dozens and dozens of cases brought, and that they constrain even ex ante already the lawmaking powers of sovereign nation states, because they're afraid that they might face multi-hundred millions of dollar litigations. Another issue, of course, is sovereign debt. The extent to which sovereign debt is used is also to constrain states, especially when it's denominated in foreign currencies and subject to foreign laws. Argentina was dragged into a court here in the Southern District of New York and held accountable and made to pay up to the vulture funds who had thwarted or had bought up cheap debt after some of the creditors did not restructure their debt after 2001. So I think it's built into these orders. At the same time, there are ways out. One is, and you see this already, people are leaving the regime. They're canceling these contracts. Even in Europe, a couple of countries have canceled their commitment to the Energy Charter Treaty, which has similar mechanisms built into, because major resource companies, oil, gas, have threatened and have brought hundreds of millions of dollars litigation against sovereign nation states if they wanted to phase out coal, for example. So they're getting out of the regime, and that's possible. It depends on the kind of treaty that you have, but it's possible. And then the final thing is that international treaties are typically subject to some broad clause, and the enforceability of commitments is subject under the New York Convention for arbitration. Some broad clause that says states can refuse to enforce certain claims if they conflict with public policy. That's the ordre public is the French term, public policy. What does it mean? So it has been interpreted in the past as like it has to be a major attack on your fundamental normative principles in your legal order. So that's difficult to meet. You can relax this a little bit and say this is not, this is not compliant with our norms and refuse enforceability, for example. So I think there are many inroads where you can change the ways in which we enforce commitments that have been made under transnational law and sort of loosen the system in such a way that there's more sovereign power. So I think we have to re-empower nation states. I would make the same argument with money systems. We have to make sure that people can have a money order, a financial order that is not dictated by the outside, but is conducive to domestic principles. It can still be made interoperable, but it has to be answerable to democratically legitimated politics.
Thank you once again. So there is another question. Yeah, thanks, Mitra, for the question. Yeah, there is another question in the chat by Phil. Phil, would you like to ask by yourself?
Sure. Thank you
Yes.
very much for this presentation. I'm just, as I was listening, I just kept thinking about what China is doing, and I'm not an expert, but it would seem that they are approaching things from an interesting perspective in terms of the commanding heights. So I was wondering if what you might think about that. Is that still within a capitalist framework, or do you see it as a potentially an alternative?
So it's a really interesting question. I've studied China also for quite some time, but I'm not really an expert on it. But I just give you what my take is on it. So I think China is a capitalist society in many ways, but it hasn't given up state control. So the combination of the Communist Party and the state that is subject to the control of the Communist Party, these two pillars are still in control, and they will rein in excesses of capitalism if they can. And they will also try to prevent the system from evolving into a situation where they lose that control. And that's very clear when you think about finance and money. I mean, they have not opened their borders completely to free capital flows. They're trying to control the financial system. They are going to stop an IPO, as we all know, when they fear that this might undermine the control structure that they've put in place. So that's the approach that they have taken, and we can go into data and other things. So it's a very centralized system. It has allowed pockets of decentralized self-governance. It is, therefore, I think, a capitalist society because there are entities that can relatively autonomously produce capital in ways that is not fundamentally differently from what we do in the West, but subject to this, very strong centralized state control. So that is an alternative. Whether it's an alternative that you want to embrace, I think, is ultimately a normative question. I don't like centralized controllers. I just don't, right? And that's sort of my liberal heart. I'd much rather have a decentralized system where we can fight over certain norms and ideas, but we basically do this within a structure that's ultimately committed to the betterment of people's lives, which I'm not sure the Chinese regime today necessarily is.
Thank you.
Thank you, Phil. Anyone else would like to ask a question? But just to follow up what Phil asked, not trying to support what is happening in China or system altogether, but you see the control over state is control of state over economy is like on the other side of the spectrum. Whereas in other states, it's like the other side. I mean, like two poles, completely different.
Yes. Yeah, I agree. I mean, but I think we also have to free ourselves from the idea that these are the two only possibilities, right? Yes. I mean, if I have to choose, do I want to have the private actors, and I think we see this in big tech, a handful of private actors who are controlling our future, right? And that's not the world I want to live in. Would I rather have sort of a centralized state? Probably, but ideally one that is democratically elected, not run by a communist party. So there, even on that side are different options. I can make compromises on one side. If we could go back to a situation where states are actually relatively autonomous from private interests, a particular financial interests, then they could also achieve many more things for us. And we also need some centralized coordination. I agree with that. And basically focusing mostly on the way we have structured the economy, and I'm trying to bring it back into a normative system that is not back. I mean, if you find, I think the quest is more radical. It says we have never democratized private law. The constitutions that we have created have endorsed a feudalist type of private law. What we want to do is bring private law to the same normative foundations on which we have created constitutionalism. And maybe that's also the only way that we can save democratic constitutionalism from its demise that we're currently witnessing, right? So that's basically my argument. What the state structures are, how centralized or decentralized they have to be, it's not something that I address in this book because I'm not painting a utopia of how this should look like, but that's the underlying normative quest.
Thank you very much. So anyone else would like to ask any question? Last chance, and then I would have to end this session. It has been already, and oh, there is one. Oh, no, this is thank you. Okay.
Thank you so much.
Okay, thank you, Katerina. Thank you for your time again, and thank you, audience. Nowadays, webinars are very difficult to organize if you don't know. Because it's Katerina, I think many has shown up. So thank you, everyone. And
thank you. Have a wonderful day.
yes, we'll be in touch.
And do share the discount, right, for people in the US.
Yes, I have already posted here, and I will write an email requesting YSI to do the same.
Okay. Cheers.
Thank
Bye-bye.
you. Bye. Bye. Bye.